All right, the motion passes. And moving on to the next item on the agenda tonight, item 9B. It is an emergency ordinance that is before us because SB-9 does go into effect January 9th of next year. And this is our time to have a discussion about any emergency ordinance that we need to adopt. So item 9B, adoption of an urgency ordinance to add Article 15 for SB-9 subdivisions. Can we get a staff report, please?
Yes, thank you, Madam Mayor, members of the council. My name is Steve Padovan. I'm the principal planner with Town of Los Altos Hills, and I will share my screen. Okay, hopefully you're seeing that. So what we're discussing tonight is our draft urgency ordinance related to Senate Bill 9. And these regulations were developed pretty quickly just because the bill was only passed in September, and we've had some quick successions of public hearings to get feedback from public and the Planning Commission. And so that's what we're discussing tonight. So these are the ordinance regulations. Again, a quick background. Senate Bill 9 was signed into law on September 16th of this year. The City Council had a discussion on the SB-9 requirements, and they directed staff to prepare an urgency ordinance and forms and such at the committee, subcommittee, ad hoc committee at the Planning Commission. And additionally, a special Planning Commission meeting was scheduled. This is happened on November 8th. The ad hoc committee, again, had a short time frame, but they were able to work with discussing issues that had come up from other members of the public and within their own committee and staff, and came up with recommendations to include in the urgency ordinance. And then on November 8th, at a public hearing, the Planning Commission discussed these urgency ordinance code language. We did receive public comment. Karen was able to provide, it was given to you as a supplemental, just a drafts minutes of the November 8th meeting. So you were able to see what was discussed, and the members of the public that had concerns and comments, and some of the discussion that occurred at that meeting. Basically, we went line through line through this Exhibit A, which is the attachment, which is all the code sections that are attached to the urgency ordinance. Made recommended changes to code language, code sections, and the city attorney's office was involved. And then we drafted this, got those conditions together and prepared this final draft urgency ordinance, which you are seeing tonight. There will be some other code recommendation changes for language that has been discussed just even today. And we've also received recently, in fact, I think we just received it half an hour ago, a letter from YIMBY, which is a group that looks at ordinances and other laws enacted at local agencies that, in their opinion, impede the development of affordable housing or just housing. And we will be discussing that letter also, because I think it's a pretty important letter to discuss. And if there are some changes to the code, we can look at that time also. And I just also want to point out this urgency ordinance, whatever we adopt tonight, we can make all the changes to code and add them in. We'll read them into the, to record these changes. And then at that point, once it's adopted, basically we cannot change the urgency ordinance at another meeting. We can extend the time period that's valid for, because it's valid for 45 days initially. And then we hold a meeting within that 45-day period. The council can only extend the time period that the urgency ordinance is in effect. We cannot change any of the codes in there. If we want to do that, we would have to actually, adopt a new urgency ordinance, basically. So we basically created these categories in the Article 15. So what we've done is we just added this on to the end of the zoning ordinance. And the reason why we did that is because we wanted staff to be able to find everything in one place in this interim period without having to search through the subdivision code and other sections in the zoning ordinance that line up with whatever these conditions are. So we've created this special Article 15 in the zoning code, and this has everything to do with the SB-9, including subdivision requirements, eligibility of properties for subdivision, objective standards for the subdivision, also requirements for new dwelling units that are not on parcels not being subdivided, ones that are being subdivided, and also some objective building and design requirements for all SB-9 dwelling units. And so this is basically what I'm going to go over tonight. I have it in some table form, so it's a lot of wording on a page, so I apologize for that, but I wanted to do that so you can see basically each code section and what it had to do with. I did not include purpose of intent or definitions. That is strictly, you can read through that, and there are some changes that may occur on some of those, but we can go into that in detail if you'd like after I go through some of the other sections that have more information that's a little bit more detailed. So again, I apologize, a lot of words on here, but I wanted to make sure if there was any sections you wanted to discuss, we could go right to at least this area, which is kind of a summary of those code sections, and then we could look in detail specifically at our draft ordinances that we have before us. So basically, just for eligibility or non-eligibility, so a parcel that's previously been split by SB-9, so in other words, anytime you split the lot, once it's split one time, you can no longer split it. So you get one shot at splitting your parcel using SB-9. Any parcel proposed to be subdivided, again, this is where if an adjacent, so you have two properties you own as an owner. Once you split one lot, since you own the adjacent, you cannot split that adjacent lot. So that's basically what this code section is saying. It's inside your ordinance language. It's basically drafted straight from the law, from the state law, but we amended it a bit so it's a little cleaner to understand. But basically the idea here is if you own two adjacent parcels and you split one of them through SB-9, you cannot split the other one through SB-9. That's basically how it's worded. Then there's also this list, these all come out of the state law about historic districts, not splitting parcels that are in historic districts, where it would require the demolition or alteration of affordable housing, rent-controlled unit, or a unit that's been occupied by a tenant for the past 3 years. In other words, you can't put a lot line through one of these units, requiring it to be demolished because of these regulations. That also applies to if you're building a new rental or a new SB-9 unit, and it would require the demolition of an existing one of these types of units. That would also not be permitted. We have here any parcel located in a zone F or zone L hazard area on our maps. And the reason why we have it on our maps is because we have splinter zones, fault lines through our town because we're so close proximity to San Andreas Fault. And so we have quite a few that run through town. It probably affects over 500 parcels. Again, the way it's worded in your ordinance, those are you can only be limited on where you can put the house. So, and obviously if you have one of these zones through your property, the whole property is a landslide zone. That means it's an unsafe building or unsafe property to subdivide or construct a unit on. And that's why that section's in there. We also have parcels fully encumbered with open space or conservation easements. And this doesn't have to mean that the existing parcel is entirely encumbered. But for example, we have some parcels that have come through our review process for a new home, and maybe half of that lot is in an actual open space easement, or it was part of a subdivision that already has existing open space easements on it, conservation easements, and the house that's existing on it already occupies all the developable area. Therefore, if you tried to split this lot, there isn't anything left but the land that's in the open space easement, and that would not be a parcel that you could do that with. So that's what that's basically stating. Or if you had a situation where the rear half of the lot, and we consider the front yard, the 40 feet in front, that may be there's nothing left to develop either. So that would be the cases where that applies. It doesn't only mean you have a 5-acre parcel that's in an open space zone, open space district, for example, like O'Keefe Preserve, which it would be also protected by this, but it doesn't fall under that type of only that type of criteria. Then also have designated as prime farmland or farmland of statewide importance. I don't believe we have any in town at this time based on the maps that I've seen from the state, but that is a designation again, and it's also in the state law. Any parcel containing wetlands defined by Fish and Wildlife, again, that would prevent the development of property. So obviously if the entire property is a wetland, you wouldn't be able to develop if it's some type of situation like that. But if you have a creek running through your property, that would be a designated riparian corridor, which would have setbacks applied to it. And you may still be able to build, but that's what the point of that is. Very high fire hazard severity zones or very high fire hazard severity zones that are indicated on maps by the state. And so we right now currently have no very high fire hazard severity zones as mapped by the state and as identified in their adopted maps. However, there is an update going on maps on these fire hazard maps, and those should be done sometime next year. And this again is just coming out of the state law, which allows us to put these requirements in here. So that's where that applies. Also, any parcel with a hazardous waste site, 100-year flood zone, and any parcel containing habitat for species. So any other questions on this, we can come back and I can explain if there's any detail of what we're looking at. For draft objectives, so this is the state allows us to put objective standards on these new parcel maps. So these parcel maps for splitting the lots can be done ministerially, which means they just have to meet some certain criteria, and it has to be a legal parcel map done by a surveyor or a certified civil engineer to create them. So that's still required. We can still charge a fee for all that, but they are done ministerially. There's no review at any kind of meeting, public hearing. And there's also no requirement to place, or we cannot put any requirements for open space easements on these maps, or even dedications for right-of-way or widening of roads. That's not permitted. But we can put easements for driveway access or utilities. So that is permitted. So we have these standards, minimum lot area. This comes out of the, again, the state law with the 1,200 square feet. I don't even think we have any parcels that are 2,400 square feet anyway, but the idea here is there's also the caveat that it can't be less than 40% of the gross lot area of an original parcel before subdivision. I.e., if you have a 1 acre lot, you could have only the smallest it could go is 0.4 acres. So that's basically what that is stating in that requirement. So in other words, if somebody wants to come in and split the 1 acre lots that are standard throughout town, which are vast majority of the lots we have, the smallest lots we'd see is 0.4 acres on those types of lots. As for the partition of parcel, we're looking at trying to divide them on the longest or the lengthier portion of a parcel. So in other words, if you have just a standard rectangular lot that has maybe 150-foot frontage, but it's 200, 300 feet deep, we want to see it split on the 200 to 300 foot deep section so that you have the front unit and then you have a unit behind. So it preserves that rural character that we have currently on our street frontages, although it does obviously allow for another house on a property behind or two houses on the property behind, if that is split such. For average lot width, the way this is worded, what we're trying to do here is try and prevent, for example, that say 100 or 150 foot lot, to split it so it's 275 or 250 foot wide lots, 275 foot lots. Instead, we'd rather have it again split on that lengthy portion. So the idea here is if you have a lot that's 100 feet wide, that is the minimum width that you could have your new lot, which would basically require you to then split it on that length division that we're talking about. As for, and flag lots would not be, are permitted. We encourage either flag lot or you could do an easement for the driveway if that's chosen in that configuration. The width of that panhandle, per se, on this flag lot would be 25 feet, which is our standard already in our current subdivision ordinance. And most of the homes in town are 30-foot setbacks from the property line. So that would easily be able to accommodate this panhandle without having to do any demolition of any existing homes, if that's the case, in most cases. Also, the front line, we're going to consider the front property line, the one that is most parallel or closest to the parallel to the street. This again encourages that type of front to back type subdivision instead of splitting a lot side to side. Separate meter required for each lot and utilities. Public and private utility easements were required so you can access the property and provide utilities to this rear property that would be proposed. Require sewer connection if it's, again, within our standards, which is within 200 feet of an existing sewer line. And so that be requirement in there, or a septic field that's fully contained within the new lot that's proposed. So if you have an existing septic system serving the home that you have that there is on the property now, and you want to split the lot, you cannot use that septic field on that existing home or serving that existing home. You have to create and have a new one prepared on the new lot you're proposing. For existing building setbacks, for lots, none are required for the existing building. And so unfortunately, what this means is, and this is the state law, if you have a house, for example, in the center of your lot, and you wanted to put the property line right at the back of the existing house or right next to the side of the house, you are permitted to do that. Now, there are certain building codes that come into play if you put a property line within 5 feet of window openings or door openings, which requires potentially either they be sealed up or changed in some way so that they meet the required building and fire codes. But this does allow for property lines. It could potentially create many non-conforming homes because that property line would no longer have to be 30 feet from the rear yard and such. So that would be the issue with that. But that, again, is a requirement that is in the state law. Now, impact fees, we are allowed to apply impact fees, which is the park and recreation fee, which we have. that would be something that we could apply on maps. And that's basically the one primary fee that we have on subdivisions when it comes to that. For notification, we are recommending a notification, or the Planning Commission did recommend a notification to all surrounding property owners. Again, it's informational only. These are ministerial and they cannot be challenged in any way at a hearing or appealed. But at least it notifies your neighbors that something's happening next door. So that's a positive, as in we're not going to have surprised neighbors if suddenly they'll know what's at least happening. Whether they're happy with it or not is a different story, but the idea is at least they're notified. Now, deed restrictions. So the idea here is in the state law, you are allowed to put a deed restriction stating that the lot was split using SB-9 rules and regulations, and that no further subdivision is permitted. So that is recorded on the property. So anybody that buys one of these lots understands that they cannot split it again using the SB-9 regulations. We're also recommending, the Planning Commission was recommending that all new units be restricted to low and very low income households. So we can have some further discussion on that. And there may be some issues of what constitutes, again, the state law doesn't talk about affordable housing. This is not an affordable housing law. And so this would be, if we implement very low and low income requirements, we would be using the state mandate or the state designated income categories. But how we look at enforcing that is something that the council can look at. And if we don't have the answer, obviously, at tonight's meeting, the idea is we're going to come up with how we're looking at that in the next month and a half or so. The city attorney's office is looking at creating these deed restriction, these formal documents that get recorded. And for an affidavit, this is also in the state law, and this says the owner applicant shall sign and record an affidavit stating that they intend to reside in one of the existing or proposed units for 3 years from the date the map is recorded. Now, there's been some discussion. Well, there's no units, say it's a vacant lot. That's the way the state law is worded. But the idea here is they're still signing an affidavit saying they will reside in one of the existing or proposed units. And again, we need to look at the enforceability and how that works. But at this time, that's what we're including in the ordinance. We also have draft objective standards now for new units on a parcel not being subdivided. So the idea of our ordinance is to try and encourage the non-subdivision of properties. We want to keep the size of the lots that we have in town. So the idea here is that what can we do to encourage not splitting the lots? So the idea here is we have the MFA and MDA on an existing lot is the same as what we have now. It's calculated through a lot unit factor that's based on the average slope of the property and the size of the lot. That number is still fixed, and it's fixed for all properties that aren't subdivided. So just for an example, 1 acre lot, you can do 6,000 square feet if it's less than a 10% slope. So that still applies. However, the idea here is if you have an existing home on the property, that's fine. Even if it's maxed out, you have a 5,000 square foot house or 6,000 square foot house on that property, you are still allowed by state law to have an 800 square foot additional SB-9 unit along with an 800 square foot ADU on the property, and still have a JADU, which is a unit that has a kitchen in it, but it is part of the existing floor area of the existing home on the property. So there's an existing primary dwelling unit on the property. You could take a piece of that up to 500 square feet of that home and convert that into a JADU. So basically 4 units would be allowed on the property, and this is by state law, but we're giving an incentive to not split lots by saying if you make the new SB-9 unit that meet all the setbacks that we currently have, which is 40 foot in the front and 30 feet in the side and rear, that if you have additional MFA on the property, so you haven't maxed out the MFA, you don't have a 6,000 square foot house, you have a 5,000. You have the additional 800 square foot of MFA, you could go up to 1,600 square feet for this SB-9 unit, this additional dwelling unit, still get the 800 square foot ADU, but then we'd be asking that you sign a deed restriction that states that you will not split the SB-9 unit. So it's a voluntary deed restriction that if you want to have the 1,600 square foot option, you would be signing this deed restriction that would say you would not be splitting the parcel. So that's the incentive that's been given to have these done. Now, with the current state law, if you don't want to do the 1,600 square feet, you just want the 800, you could go with the 40-foot front property line still stands, but you'd only need to go 4 feet from the side and rear property line, just like an ADU. So it's the same regulations as an ADU, 800 square feet, 4 feet, side and rear property line. For an example of the ADUs we've had constructed in the last 2 years approximately, I think we've only had 1 or 2 that are less than 10 feet. In general, and they were all single story, and that's what these would be. All these new units on lots being not subdivided, 16 feet is the maximum height. So the idea here is a lot of these regulations we already have with ADUs. So you're not seeing, hopefully, additional intensity on this, even though it's allowed an extra 800 square foot unit. It would be similar to the ADU impact that we've had, which luckily at this point hasn't been as significant as we had thought. Still significant, but not as significant as we had thought. For parking, we have requirements for 1 uncovered parking space outside of the yard setbacks. And the reason why we have that is because we don't have on-street parking. We do not have the ability to use pullouts and curb cuts and things like that. So the parking has to be on the property, and there isn't any bus service throughout town. And there's also, except in the peripheries of the town at Foothill College and along Restradero. And also there isn't any ability to, there is some the regulations in the law state about car sharing and things like that, but that is not really an option in this town. So we are requiring the 1 parking space for each unit. As for duplex unit separation, we're saying if you want to do an attached, because you could do that. So you have a vacant lot and want to put 2 units together, or attach the SB-9 unit to your primary dwelling unit. There has to be a solid 1-hour firewall between the units, no doorways, nothing. So that way it's a completely separate unit from the units, from each other. There's no like doorways between 2. Again, we talked about the deed restriction for the 1,600 square feet. And again, this only applies if the owner utilizes that incentive, which is to do the extra 800. And that SB-9 unit meets the setbacks, which is 40 feet on the front and 30 feet in the sides and rear. And then the affidavit says that you will reside, actually it's just the intent to reside in one of the existing or proposed units for 3 years from the date. And that's, sorry, I got the wrong one on there. That should be that the date that the any new unit is constructed. So the certificate of occupancy is a date that it's constructed, and that would be within that time, be occupying that unit once that's built, a 3-year period within that time. Just some continuation again, septic and sewer, same as pretty much on the lots with regarding require sewer connection or septic. Pools and patios and such are not permitted in the setback. So if you want to do additional hardscape associated with an SB-9 unit, that all has to meet our standard 40-foot and 30-foot side, front and side yard setbacks. For rental of the unit, no dwelling unit shall be rented for a period of less than 31 days. Basically, you can't create these for short-term rentals, Airbnbs, things like that. That's not permitted. They can be rented separately though from the primary dwelling unit. You could even rent both units on the property and not live there once that 3-year period has extended beyond that. If there are any questions on that. As for impact fees, again, all the impact fees, such as the school impact fees and then all development fees that we have, those do apply to any new unit, just like a regular single family house. They're not exempt like what we did with the ADUs, where the council allowed ADUs to not have to pay some of the fees because we were trying to get the affordable units reached in our RHNA goals for cycle 5. For new units on subdivided parcels. So here's where the restrictions really come into play, because again, we're trying to encourage non-subdivision of existing lots. So however, again, if it meets the criteria that we stated in the previous section, you can subdivide the lot ministerially. So the idea here is you're allowed 2 units on a lot, either the primary dwelling unit that's already there and another SB-9 unit, or if it's vacant, 2 SB-9 units. We're allowing only a maximum floor area of 1,600 square feet. Now, again, if you have an existing house on there, that existing house can stay, but the residence cannot be increased. The area of the residence cannot be increased. And again, the additional SB-9 unit shall not exceed the 800 square feet. Maximum development area, 1,600 square feet plus the 2,100 square feet. This 2,100 came out of our regulations for CDP lots. Basically, it is about the amount of area needed for driveways, potentially fire truck turnarounds and such that are required. And it seems to work very well with the CDP lots, as in it's an adequate amount of area allowed. And so that's where that number comes from. It's not just a random number where we came out of nowhere. Again, for the exception, you have existing dwelling unit property, and you have some maximum development area on the property. So say you already have a 5,000 square foot home and you have 10,000 square feet total of development area. you get an extra 800 square feet for the SB-9 unit. That's what you get on that for development area. If you have nothing on it and it's vacant, you get the 1,600 plus the 2,100. For minimum setbacks and floor area, 40 feet from the front property line and 4 feet from the side and rear property line. Maximum floor area again is 800 square feet. Basements are not permitted. Now there is this caveat in the state law that no setbacks required for a dwelling unit, SB-9 dwelling unit constructed in the same location as the existing structure. There are situations in the county lands that were annexed down the southern part of town. There are some garages built on property lines and some other structures that are very close to the property line because that's the county allowed detached structures. So you would be able to put a new SB-9 unit on one of those, like the footprint of one of those types of structures, as long as it was legally created. So we would be looking back in the building permit records or whatever to confirm that it was legally created, but that's what that exception comes from. Maximum height, again, we're looking at 16 feet, and any maximum height of an existing residence cannot be increased. So again, we take an effect that if there is an existing home there, it's basically fixed. That's what you get for the existing home. And for parking, one uncovered space outside setbacks, again, required if you're going to put a duplex, 2 houses on one lot, and you want to attach them, solid 1 hour firewall between the units is required. And a deed restriction stipulating that the duplex shall be maintained as 2 separate units. So these are all some requirements to try and discourage somebody coming in, like a developer or such, coming in, building a 1,600 square foot duplex and then popping a hole through the wall. The idea here is that these need to be, this would be recorded. And if something comes, if that does occur, then we could enforce that or require the opening to be sealed again. If, for example, if we in the future find out that they come in for building permit and say, well, what's this door here? Or what's this opening? And would allow us to reseal that and make it a solid 2 separate units again. Deed restriction, if the property is fully developed with maximum units, the owner shall record a deed restriction stipulating that no further development is permitted. And then again, we have an affidavit that they'll live in one of the units 3 years from the date of issuance of certificate of occupancy, the SB-9 unit. And sewer septic require a sewer connection or septic field fully contained within the parcel. Pools, patios not permitted in the 40-foot front or side yard setbacks. No dwelling, again, rented for 31-day period, less than 31 days, and can be rented separately from the primary. And then again, impact fees all apply. These are not affordable units, but we can designate them as affordable. And if we want to look at reducing development impact fees, that could also be another encouragement of making them affordable too, if that's something that the council wants to look at. And then last but not least, on the objective standards, these are what we can apply to all new structures that are SB-9 dwellings. And these are, again, they're considered objective because they apply to every parcel, every home that's proposed. So the idea here is we're not doing anything that would impede or cause additional construction costs, on a unit or limit its ability to be constructed. We're just asking for materials that match, look like the existing structure that's there if there is one on site, or if obviously it's an attached unit that's using existing materials and such. We also are allowed to impose our color requirements, LRV, that's light reflectivity value of 50 or less for the structure and 40 or less for roof materials. This is standard on all our homes throughout town and also on our ADUs. So a lot of these regulations are same as our ADUs. Exterior building lighting, again, limiting building lighting to fully shielded and downward facing. Limit light fixtures, 1 per doorway, or the minimum necessary to comply with the building standards code. We do allow some, obviously, recessed lighting over covered patio areas and such. So it's not that you can't put any kind of lighting like that, but the idea is to try and limit the excess lighting, especially when it's a building ends up being only 4 feet from the property line or something like that. Fire sprinklers are going to be required for all new units. This is just standard with the building code. Structure setbacks. We're stating that basically any kind of eave overhangs and other projections are part of that setback. So if you're going to do a 4-foot setback on your proposed building, that's to the roof eave, not to the wall. So that's we have that in our ADU ordinance also, and there's nothing that prohibits us from requiring that. As for structure location, this is where there was some concern of what was if we're doing something that would be potentially not objective. But the idea here is that the state law says that as long as you can build an 800 square foot unit, and that if we impose these types of setbacks, it doesn't limit you from building that 800 square foot unit, that would not be an infringement on your ability to construct the unit, so which means it's not in violation of the law. So basically what we're looking at here is any areas encumbered by recorded easements. So if you have public utility easements, conservation easements, open space easements, pathway easements, any kind of other access easements, none of those can be encroached on with the new unit. If you're within 25 feet of the top of a bank, this is a standard we have already in our code. It's a 25-foot setback. We don't allow that for any structures. Now we can't impose an easement over it at this time, but we can restrict the ability to put the structure within that 25-foot setback. In areas with critical root zone of a heritage oak. So this is, in other words, if you have a large heritage oak on the property and there's other areas you could locate this 800 square foot or potentially, I guess, the 1600 square foot if you're meeting setbacks, and it's not subdivided, that would be another situation where we say, okay, you can't be in the critical zone. You need to relocate it or move it out of that area. We also have this that was thought up at the planning commission meeting of 10 feet from the parcel line where a pathway is designated on the master path plan. So we have a master path plan that's been adopted by the council as part of our general plan, and it identifies potential corridors where pathways will be going through. And most of these areas where this is affected would be these off-road pathways. In other words, there's a pathway connecting neighborhoods that goes between properties. And so if somebody comes and wants to put an SB-9 unit on a property and we find that there is a pathway and there's no easement there, but there's going to be a future pathway potentially there, then we can require the 10-foot setback off that line, because that's our standard 10-foot is our standard pathway easement that we get on properties. In some cases at 10 feet, if it's a steep lot, well, that's not ideal, but it had to be an objective standard that is typical of what we would allow on most properties. So that's why we picked the 10 feet. And if it is steep, then I guess the pathway would have to have some kind of steps or something in it in that case, because it wouldn't be able to zigzag up, obviously, in that area. And also we have in areas slopes greater than 40%. So the idea here is not to be building on steep slopes. We do have some existing parcels that are over 40% now, and that's the average slope. But again, for an 800 square foot unit, the idea here is as long as you can find a place to put this on the property that doesn't infringe on any of these areas that we're suggesting, that's fine. However, if for some reason that there is no place to put the 800 square foot unit based on these criteria that are in here or any other criteria, then these are waived. So in other words, we can't prevent you from putting one 800 square foot unit on the property. And so that's why we have that caveat in there. And then we're also requiring that all electric and utility services to the new dwelling unit be undergrounded. Again, this is standard with all of our new ADUs that are detached, all of our new residences and such. So there was some discussion on, we were looking at how the code was worded, the proposed ordinance was worded, and we've decided that staff feels that there should be a couple of additional changes regarding housing developments. The way we worded the code section before, and this is the one that's relating to the where housing can be built on the eligibility of properties for subdivision. So in that section, it talks about a lot of situations where there's property encumbered with fire hazard zones, flooding and such. But we didn't directly relate that to, well, can you build a unit on one of those types of areas? And so these are two code sections that we're proposing that be included. So these would be added to sections 10-1.1505. There'd be subsection O, notwithstanding the foregoing, no housing development project shall be permitted on a site pursuant to the article, and the underlying also falls within those other code sections that we talked about with regarding plot splits. And we did that also for the other code section 1506. So we'll read these out when if there's no issues with including these with the draft code language that we have. These would be two code sections that we want to add to the ordinance. And then there's also one of the planning commissioners wanted to have some clarity to just show that you cannot have more than 3 detached dwelling units permitted per parcel. So we suggested adding to section 10-1.1505 to read that sentence be included. And again, we'll read that into the when we're prior to the adopting the ordinance, we'll read these changes into the record so that we have it and it's part of the ordinance. So our recommendations at this time are to review and discuss the proposed code amendments, to accept public comments, and then to agree on any changes to the text in the ordinance in Exhibit A, and then that the ordinance is adopted, no amendments can be made to the specifics. So we need to understand that once this ordinance is adopted, we cannot change the text to it. We can extend the time frame, but we can't change the text to it. Just want to make that clear. And also, we're recommending waive reading, introduce, and adopt the urgency ordinance with the text amendments as read into the record. I do want to bring up, before I finish, and I've talked long enough, so I do want to bring up the fact that this letter that we received, and the attorney can probably also maybe chime in on this. I know that's, I think, what Steve was reading before looking at. They have pointed out some code sections in our proposed ordinance that they say are in violation of state law.
Yeah, Steve,
Yeah.
Steve, I would recommend that you, counsel, we can address that letter after the public comments come in. Steve, I'd prefer we not address it until. I'm happy to address the points in that letter.
Makes total excellent sense. Okay, so basically, then that concludes my presentation, and I have I kept those examples of where we had the boxes in the property lines. If you want to see some of that, I have those just to get some ideas if you want. I do have some of those that we can go back and forth or go over any text that you have, but I'm definitely available to answer any questions, which I assume there's many. So I would, again, open it up to questions and answers.
Thank you, Steve. Excellent presentation. At this time, I want to take questions. Let's see, George.
Thank you, Mayor. And thank you. Boy, what a collection of staff reports we've gotten so far tonight. I'm really feeling enthused about the people we've got on our team here. And also for those of you in the audience, and you're looking at SB-9, and the whole idea of this was to increase housing in this state. We understand and recognize that housing is a serious issue in this state. And what we feel our duty is to help make sure that we're protecting their community, a community that has not been a source of employment growth, a community that is not close to transit, and a community that has many fire potential dangers due to our hilly terrain and narrow streets. And so that's a little bit of the context. And the rest of the context is just like the other council members. You may find if we don't have a lot of questions here, it's not that we haven't studied this, and it's not that anything has been rushed, even though there's a lot going on. There's been so much thought put in because it's a priority. I think we're hearing from our residents, this is a priority that we find a way to address this. And so for me, for example, I met with our new city manager to talk about this and had questions, and they were all answered by the staff ahead of time. So the only reason I'm here speaking today is because a new question came to me, and then also to give a little bit of the preamble that I just gave. And so beginning back to that fire danger issue, Steve, what I think I heard, I wasn't quite sure where we ended up, because I realized there are fire maps that are being developed now, and there are fire risks that we see now that we didn't see 3 years ago. For example, high wind and the impact of that on our fire risk here. And so I'm just wanted to clarify, are we anticipating what those new maps might look like so that we don't find ourselves trapped in an old map that doesn't show the real risks that we're actually facing now? Can you help provide clarity on that?
Sure. Yes, I have. Over the last year, there was actually some. In fact, Berkeley had some really good. They were putting on some Zoom meetings with some of the state forestry people and some other individuals that were showing some of the changes that are going to be happening to the fire maps that are much more accurate than what we have now. The maps we have now were adopted back in 2008. Didn't even anticipate things like Santa Rosa, where it burned parts of the city that literally that wasn't in any fire hazard zone, but hey, it burned, you know? So the idea here is that they're definitely taking into more consideration the distance that fires can jump with the winds. They're taking into account the types of fuels and how they're situated on the terrain. And they're also looking at just existing, they're finding many of the reasons that fire spread was the homes burning in the communities caused the fire to spread more than the actual trees and things like that. So a lot of this has to come into play with the new fire maps, but we don't have anything to disperse at this moment or to show you because, again, they're still working them all out, and they just give us timelines potentially next year, but there's nothing concrete. So the reason why it was written the way we wrote it in the urgency ordinance, that's what the law states. The state law indicates what you can use for wording. Yes, we don't have very high fire hazard designations in this town. Very close to us in Cupertino they do, but we don't have them here. But we're clearly in a zone that is understood that there is fire hazards. So the idea here is that, we may not exactly fit the criteria that state map is indicating, but it doesn't mean that there can't be a consideration by the town to look at, is this seriously a consideration for, this is a fire hazard? Should we be allowing double the density in some of these areas? So again, we've put the wording that it has in the state law. Will it prevent lot splits at this moment? Maybe not. But it's definitely something that we can look at and at least categorize and consider. And also, the fire department has stated that, all the regulations that apply to that we have for width of driveways and such, that can apply to these new lots and new units. So in other words, if somebody wants to split a lot up in one of the areas that's very far away from the public road and it's a narrow road, that can actually be a requirement that they upgrade the road all the way to the home because they're splitting it and adding an additional density or adding additional units to the property. So again, if it might cost, I don't know if you've seen the Sherlock Road project, but they're literally having to do 1,000 feet of road because they're putting a brand new house on a vacant lot. And it would be similar to somebody wanting to split a lot that's far away from a public road that doesn't meet the fire truck requirement. So whether it's an actual high fire hazard zone, we can still regulate, we can still look at fire hazard concerns when we're looking at these lots.
Thank you.
All right, any other questions for Steve? Lisa?
Yeah, this is more procedural question. So if we adopt this emergency ordinance, the next step after will be drafting a more permanent ordinance. This gives us time to give this more consideration. Is that the correct way to say this?
That is correct. Yeah, this is an urgency ordinance under Government Code Section 65858 is really intended to have the town have temporary regulations in effect while you draft more permanent ones, and those permanent ones would go through the typical zoning amendment process that the town follows, which would be public hearings before the Planning Commission and City Council. In this instance, the issue at least has been considered by the Planning Commission already, but when you adopt the permanent ordinances, if the town chooses to do that, you would go through a noticed public hearing process through both of those, through the Planning Commission before it comes to the City Council.
Is there a time limit on creating the permanent?
Yeah, there is. So the under Government Code Section 65858, this ordinance can be adopted this evening and it can only be effective for 45 days. There are procedures under 65858 that allow you to extend an interim ordinance up to a maximum of 2 years from its initial adoption. You have to do it in 2 stages. There are different ways to do it, but you get up to a maximum of 2 years. And there are very specific findings that have to be made when you are, when you're extending an interim ordinance that relates to housing. In this instance, because both the interim regulations and what the council might adopt subsequently, if you choose to adopt anything else, you're actually increasing the number of units that can be placed on any of the units because SB-9 does that. And the council is not restricting in any way the total number of units that SB-9 allows. Your ability to make those findings is is greater because you're not actually reducing, nothing that you would regulate would be reducing the density of the potential development on the properties. In terms of number of units, I want to be very clear about that.
Linda?
I also talked to Peter, but I some more questions came up. Like the 600, you could have 1,600 square feet for an SB-9 on a parcel that's not subdivided. Plus on the other ones, we're putting lots of little structures all over. So keeping them all one story, it seems like you're covering a lot of the lot and maybe increasing more rain runoff. Has that been considered? Because I know we want to keep everything low, but it might have the unintended consequence of having a lot of rain runoff by covering a lot of the lot on these little single story units. And then on the deed restrictions, I wanted to know what the penalties would be and how these would be enforced. And Steve said something, we couldn't change this after tonight. So I wanted to get that done, but maybe based on Lisa's questions, this is not the final ordinance, that we could change it later on and clarify what the deed restrictions
Yeah,
are.
that's correct. This is an interim ordinance. The council will have the ability to adopt a permanent ordinance. The deed restrictions that we, that are being considered here would be enforceable by the town, because the town would be a beneficiary of the deed restrictions and would have the ability to enforce them if they're adopted. So for instance, a deed restriction not allowing further subdivision of a lot that's been subdivided once by SB-9, the town could enforce that. The same would be true if the council were to adopt the affordability provisions that are included in this ordinance with regards to lands that are split, that have a subdivision, and then build the units. The town would have the ability to enforce that, would have the right to.
Okay. And then when Steve was talking about locations of these units, like the away from the creek beds and the 40%, I think that should be taken into account when they do the lot split. So that you don't split it so that the only thing that's left are these areas that are in these zones that you don't want houses. You know what I'm saying? So if you're splitting the lot, you say, okay, put all the 40% in the lot split, and then we have no choice but approve it. Whereas there may be plenty of space if the lot is split in a different way. So can we make it that they have to split it so that we avoid this having to let them violate these requirements?
Yes, so that's exactly why we have that code section that talks about what parcels can be subdivided. So if you have a situation where, so you have a creek at the back of the property, an open space easement, a fault, all these things going on, and you want to split that piece off and there's nothing left to put the home in, because with the 40-foot front setback, which we're allowed to require, there's nothing left, then we would say that parcel map is denied. Because again, ministerial, we don't have to approve it just because it's ministerial, we can deny it. We can just say there's no place to build your 800 square foot unit because the way you've planned out your lot, you are denied. So that's how that works. As for the, I think I heard you talk about the concern about the runoff. Well, definitely if you have a 2-story building that has, that's one story, one level on top of the other, yes, that obviously reduces the amount of runoff. But the significance of 1,600 square feet, or say if it was 2-story, and so instead of 800 square feet, you're looking at 1,600, it's only an additional 800 square feet of runoff, which is not substantial. We have plenty of projects in town that are much more significant than that. We can easily mitigate those with our existing stormwater systems and our retention basins that we already put into place.
Okay. And then one last question for Steve. The law says that you have to sign an affidavit that you intend to reside, but that's pretty wishy-washy, right? Because today I intend, but tomorrow I don't intend.
That is, yeah, that is a weakness in SB-9, but it is not one that the town can addressed through more stringent regulations. The law allows the city to receive a statement of intent to live in one of the units, but the law does not allow the city to, for instance, require an owner occupancy requirement beyond just that statement of intent. And the town is prohibited from requiring a further deed restriction on that issue.
So there's no penalty if I change my mind.
Yeah, the law does not provide a penalty. I mean, in theory, you could say that you are therefore not qualified for the SB-9, but once the unit is built, that is very difficult to, practically you can't undo that. And because the law only requires that it be an intent to occupy, there is a reality to the fact that people's legitimately held intent changes over time, and that is a shortcoming of the way that the law is drafted.
Okay. All right.
Lisa?
So what do we give up if we don't adopt this urgency regulation tonight?
The law specifically allows the application of objective design standards and objective subdivision standards. So standards that do not require the exercise of any discretion, either by staff or by the planning commission or the city council. And so if the council does not adopt objective design standards, then you would not be able to apply any design standards or subdivision standards other than the minimal ones that are identified in SB-9. SB-9 has a setback requirement of 4 feet from the side and the rear yard, unless there's an existing structure built to the property line. SB-9 has a few other requirements, but they're relatively minimal requirements, and that's all the town could apply then. So it is, the drafters of SB-9 did provide cities and towns the opportunity to have objective design standards and to apply those, as long as those standards do not effectively prohibit the construction of a minimum of 800 square foot units themselves. Not 800 total on the lot, but if there's 2, they each have to be a minimum of 800. Beyond that, the town is not preempted.
Linda?
I'm still confused about the deed restriction for the low and very low income. Okay, so what's the penalty if I rent it to someone who doesn't meet that requirement? And how are you going to enforce it? Do I have to every year give these tenants tax forms to show that they meet these requirements? If they get a brand new job and now are above that income level, do I say, oh, congratulations on your new job, now you have to move out? I just don't understand how it's going to work.
So those will have to be developed further with the permanent ordinance that comes through. Typically what happens with deed restricted affordable units, when people's income rises to a level where they're no longer in a very low or low income category, is that you don't typically cause them to end their tenancy right away, but the next time the unit becomes available as a rental again, you then require that it be rented to either a very low or low. In terms of enforcement, the town, so cities that have existing rent regulations like this that they adopt, there's typically a reporting requirement that is oftentimes on an annualized basis. There might be a registration requirement. I can think of, for example, I've dealt with a project in Hayward where the city actually requires you to register the rental unit, and then each year you have to make a certification to the city. And then if the town chooses to enforce that at whatever level the town wants to, they can. From an enforceability standpoint, the city would have the right if, for instance, a landowner created one of these units and just continuously rented to someone who was not qualified, the city could go in and seek an order from a court directing the property owner to rent it at the appropriate rental restriction level. But it does require active enforcement from generally the town, or if the town contracts with some entity to do that, do that monitoring on their behalf. That's another way to do it. Obviously, Los Altos Hills has a much smaller staff, number of staff than other cities that have much more rigorous rent restrictions that they enforce on a regular basis.
So is there a penalty, or do I just wait? If I rent it to someone who's not low income, is there a penalty, or do I just wait for the city to come in and sue me and order me to correct that problem?
So that would be drafted in the rent regulation documents, the rent restriction documents. We're not proposing that to the council tonight. That is something that we would look at. You can impose a penalty on a landowner who violates the restriction, but that's something that we would propose to the council with the rent restriction documents if the council wants to go in this direction.
Okay, all right, thank you.
Dan?
So I must confess, I really don't know exactly what's going to happen here, but from my understanding, there is a flow chart to be drawn here. If we pass the ordinance tonight, then that mitigates the effects of SB-9 for a period of perhaps 45 days or so. If we don't pass the ordinance tonight, then the SB-9 is unmitigated in its effects on our city. So I would say that I would encourage the passage of a 45-day ordinance. Now, where I have a source of confusion is that what happens after that 45 days? Can we enact permanent ordinances that are not emergency ordinances? Can we extend the emergency ordinance for another 45 days? Or is it possible for us to mitigate the SB-9 in some other fashion? So, Steve?
Yeah, so the ordinance that you're adopting this evening can be extended. It can be extended for up to a maximum of 2 years total from the initial adoption. So from today, if the council were to adopt it today. Every extension, like the action tonight, requires a 4/5 vote of the city council, which is not typical for measures that come before the council. So it does require a 4/5 majority every time. And yes, Councilmember Mock, ultimately the town would consider permanent regulations, and those would be done presumably sometime next year. The purpose of urgency and interim ordinances is to allow the town time to adopt permanent regulations. So the town would be adopting these tonight with the idea that they would be considering permanent regulations. And the permanent regulations could be similar to what you adopt tonight. They could be different than what you adopt tonight, but they cannot violate the restrictions of SB-9. So ultimately, the authority that is being presented to the ordinance that's being presented to the council tonight is implementing some of the authority that SB-9 grants to cities and towns. And so it's possible that the permanent ordinance could very well look very similar to what the interim ordinance does. That's what many cities did with accessory dwelling units regulations when those first started to come in. They adopted interim ADU regulations and then ultimately made them permanent ADU regulations. And Steve, I believe we did that in the town as well too, didn't we?
I don't know if we had an urgency ordinance for ADUs. We had drafted one, but then through some corrections, we adopted another one after that.
Yeah. So this is an approach that is being considered by a number of cities right now.
So, Steve, if we do pass the ordinance today, what would happen after the 45-day period, if we wanted to change some of the original conditions of the ordinance, what percentage of that ordinance that we passed today can be modified, can be amended? What kind of codicils can we use?
Well, it's, so if you remove any restrictions that are adopted tonight, I don't think there's any limitation on that. But I would not recommend that you add additional regulations beyond what are imposed tonight until you adopt the permanent ones. And so, and you could, you know, so the council's aware, you could commence the process of the permanent ones, and assuming that, you know, you have staffing availability and whatnot, you could have the permanent regulations back to the council in 2022. That's quite conceivable. It could even be, you know, maybe by mid-year. And so if the council's thinking about modifying the regulations to add more requirements, that is something that I would probably caution you against. But it's not completely prohibited by the law. It's just that the idea is these are interim regulations while you try to adopt your permanent ones. On the other hand, if you want to remove some of the restrictions, that there's no restriction on that. So.
Thank you, Steve.
Steve, I have a question. So what is being proposed tonight seems to say that any housing created on account of a SB-9 subdivision can be mandated as being affordable. But what happens if housing is created without a subdivision? It doesn't seem to me as if that is required to be affordable. Is that correct?
That is the way that the ordinance is structured tonight, that it applies to the units that are built on the subdivided lots, as opposed to all of the units.
And why is that? What is the difference? Why different sets of criteria? Because to me, the letter and spirit behind SB-9 originated from the fact that there was an urgent need to create more affordable housing in this area. So why have we made a differentiation between lots that are subdivided and the lots that are not subdivided? Because housing is being created on both.
Understood. Steve, do you want to take the first shot at addressing that?
Yeah, definitely. So the planning commission, when we were looking at these regulations, the idea, again, we're looking at minimizing lot splits. And so the idea here is if you keep the lot together, you can put an ADU, which is an affordable unit, on your property. So the idea is there's already an accommodation for an affordable unit on your property, so that you didn't need to. So we didn't want to impose two affordable units on your property if you weren't splitting the lot. So in other words, it was again another way to say, well, we retain the lot as one lot. We prefer that. You could still build an affordable unit, an ADU, and it's not even, and you know, so that's roughly mandated or it's allowed. And then you could have still an SB-9 unit if you want it for an in-law or something that you don't have to be as concerned about whether it's an affordable unit or not. So that was the idea. Is there's already the affordability equation with the ADU on a lot that's not split. However, if you're splitting lots, again, to discourage lot splits, we wanted to also say, okay, fine, you're going to split the lot, then we want to see affordable units built because you're increasing density on the properties. We want to see at least, you know, some affordability with those units.
So, Madam Mayor, if I may add to that answer.
I guess
yeah.
Rationale that there's already one unit on that lot that's affordable, so we don't want to over restrict.
Right.
But the problem with that is that SB-9 development can be ministerial. So you could have somebody go in and say, hey, I don't want to go through the whole process. Let me just go ahead and do a ministerial, get a ministerial okay and do a development. It's not affordable, you know.
Well, so
when the law.
Yeah, Madam Mayor, so ADUs are ministerial as well too.
Yes.
And so there is an issue of the way that the town has treated ADUs. ADUs themselves may qualify as affordable units. And Steve, correct me if I'm wrong, they're not deed restricted as affordable units.
Exactly. They're
correct?
not.
They're
Yes.
not.
exactly.
So that is a very fundamental difference. So if you think about an ADU, you can get on a property right now, and by law, it can be 800 square feet. And the town does not deed restrict that affordable. They may in fact be affordable, but you don't require it. And so now if you have an SB-9 development where you have the primary, the existing house right now, and you add another unit by SB-9, and you've already restricted its size to 800 square feet, possibly 1,600 square feet. If you're to make that one deed restricted, then the applicant could just simply come back in and say, I'm not asking for an SB-9, I'm asking for an ADU. And the ADU is not deed restricted from an affordable standpoint. That's different than a lot split under SB-9. And I would say that, you know, the SB-9 does not specifically authorize affordability restrictions, nor does it prohibit affordability restrictions. And so if the council is interested in increasing the number of affordable units, actually affordable, enforceable affordable units in the town, then this application of the affordability requirement to lot splits is a way to do that. I would respectfully disagree a little bit with the way it was characterized before as a disincentive. The town cannot prohibit lot splits, but what you can do is place restrictions on the units that are created by virtue of a lot split. And so the policy question for the council is, do you wish to have affordability requirements? And if so, on what kind of units? And the proposal that came from the Planning Commission and staff is to impose the affordability when you have lot splits, which is within the council's authority. But it's really within your regulatory authority. It doesn't actually derive out of SB-9.
I see what you're saying, but what if there is an ADU and an SB-9 unit? You can definitely, you should be able to mandate at least one of them. That they
Well, right, you could, but if the council wanted to draft it to accomplish that, then you would want to very specifically say that if there's an SB-9 unit built in addition to an ADU, because if you don't do a lot split, it is conceivable that you could have on one lot a primary house, an SB-9 unit, an ADU, and a JADU, all on one lot.
That's possible. We could clarify that.
It is written that way.
It's just, I'm concerned that people could use that as a way to circumvent our planning process by doing a ministerial, you know, because this is ministerial.
Correct, Mayor, but ADUs are also ministerial. And
Yeah.
so I would recommend to the council, you change the way that you're looking at this and just decide, do you want affordability? That's really the issue. And then how do you impose that if you want it, rather than thinking about it as to how someone might utilize SB-9, because the number of units that can be created is, is practically already, well, it is actually already controlled by SB-9. So the number of units is not what the council has the ability to control, but the affordability of any SB-9 units you can control.
Okay, so I have a question for you, Steve. In terms of having a conversation about restrictions on affordability, when is the time to have that discussion? Should we do it now or after public comments? Maybe we should hear what the public has to say and then bring it back.
Yeah, I would recommend that the council do it after you hear a public comment on the issue.
Any other comments? All right, seeing none, I will open this up to public comments. Sasha?
Hello. I just wanted to point out that the 3-year intent to occupy seems to start from the moment of the lot split, and SB-9 does specify that.
All right, thank you, Sasha. Brigida?
Yes, good evening, City Council members. Thank you so much. I have to do a big thank you first to Steve Padovan for the excellent job pulling this together so quickly with so many details to everything. When we had this Planning Commission meeting, we kept on pushing the fact that we thought that, you know, for any SB-9 application, be it a lot split or not split, it should be affordable. That was the thought that we had. We kept on trying to go around and around in circles trying to figure this out. And so I know for myself also personally, I think that I like to see a deed restriction for all SB-9 units, be it on a lot split or a non-lot split, should be deed restricted to affordability, because that was the intent of the law. I went back and listened to the October 26, 2021 webinar with State Senator Michael McGuire this evening. And he said 3 times through this whole proceeding that deed restrictions are allowed for SB-9 for affordability by city councils. And he went for a couple more times throughout the whole presentation saying, yet again, you can deed restrict all SB-9 units. They can absolutely be deed restricted for in perpetuity. And then also, of course, he reemphasized the affidavit for owner occupied, that impact fees be honored. You can deny housing based on water supply and fire risk. So I'm just kind of going back to hear our State Senator Mike McGuire, who is a co-sponsor for SB-9, is saying that he's giving the right to all city councils and county commissioners or county supervisors to do deed restrictions to create affordability. So I'm just kind of going back to why we have SB-9 in the first place. And that's what I really would like to urge, a deed restriction for affordability for any and all SB-9 units. And it's different from ADUs. ADUs, that's come and gone. So now this is a new one. Thank you.
Thank you, Brigida. Salim?
About Los Altos Hills that I think is informative. In 1973, there was a lawsuit, Jackie Berra versus Town of Los Altos Hills, where 2 defendants, Jackie Berra and Jose Vasquez of La Raza Unida Party, sued the Town of Los Altos Hills in the U.S. District Court for the Northern District of California. La Raza Unida had bought an option on a parcel of land. They wanted to develop that land into housing that would be affordable for working class families, specifically Hispanic families. But as you know, the laws in Los Altos Hills, the single family zoning combined with the minimum lot size requirement of 1 acre made it impossible to build housing that middle class families could afford. And in that court case, according to Judge Weigel, the defendants, that being your town, quote, stipulated, though reluctantly, that it would be very difficult, if not impossible, for persons of low income to obtain housing in that city, end quote. And that's obvious. If you mandate that people have to own 1 acre of land to live in your city, it is extremely hard for low income people to live there. And the effects of this law are apparent. It's obvious. Drive around. If you look at all the mansions, it is not an accident. It is a requirement of the city. If you look at the demographics for Los Altos Hills, why are there so few Hispanic people in Los Altos Hills? Not an accident. So I want to be clear, I'm not singling out Los Altos Hills. A lot of cities have racially exclusionary and socioeconomically exclusionary policies based on the past. But what's unique about Los Altos Hills is that the city has done nothing on its own volition to mitigate exclusionary zoning. The affordable housing that's built in Los Altos Hills through the ADU law, not in Los Altos Hills' volition. The success of that affordable housing program is a success story for state preemption of local control. This is an extension of the same exclusionary history in that 1973.
Thank you, Salim. Rafa?
Yes, good evening, council members. My organization sent the letter, which you may have read or may discuss later this evening. We're concerned that there are a number of problems with your ordinance that violate or would violate state law. And while the town of Los Altos Hills has the right to impose objective standards, the process by which you're doing this is problematic. As your attorney mentioned, you have 45 days to have this temporary ordinance. But after that, he's misleading you because the requirement is for you to show that there are specific adverse health and safety impacts that your ordinance is mitigating, and specifically in this case, SB-9 allows additional development. However, you will be restricting that development, and that includes restrictions on floor area ratios or lot sizes and setbacks and other requirements that reduce the intensity of development, which would be illegal under SB 330 today or SB 8 on January 1st. So you have to think very carefully about the approach that you're taking. We'd recommend that you adopt an ordinance in the standard normal procedure rather than this urgency ordinance policy. It's a dangerous road that you're going to go down and could potentially find the city in legal peril. Thank you very much.
Thank you, Rafa. Anne?
Thank you for all the work you've put in on this so far. I just wanted to say on your list of eligible or ineligible properties for SB lot splits that you include pathway easements. You have already in the wording that you showed tonight included open space easements and conservation easements. I would like to see pathway easements included in item 6 of the, on the screen that you showed us this evening. And then this is maybe a question for Steve Mattas. There are a couple locations within the proposed urgency ordinance where you talk about the affidavit and the intent to occupy, which starts running with the date the map is recorded. I would prefer to see that date the clock start running after the certificate of occupancy, but I don't know legally, given the nature and the wording of SB-9, whether we can insist upon the clock starting to run with the certificate of occupancy and not the recording of the map. I think the rest is good to go. Thank you.
Thank you, Anne. Sue?
Yes, I sent a query asking whether the designated open space conservation area in the town qualifies as, quote, an adopted natural resource protection plan. If it does, parcels that fall within it would be ineligible for SB-9 lot splits. The open space conservation area in the town is clearly intended to protect the environmentally sensitive natural resources in the town. The definition of it in the Los Altos Hills general plan is the open space conservation area is designated, generally applied to areas of steep slopes, canyons, and ravines associated with major creeks or their tributaries, as well as creek corridors and other areas of heavy vegetation that should be protected. Within these areas, special measures should be taken to conserve the natural quality of the area and to avoid environmental degradation. Sounds like a natural resource protection plan to me. I wonder if the city attorney could comment on whether that constitutes a natural resource protection plan. Thank you.
Thank you. Anne?
Good evening. I'm very glad to hear. This is Ann Paulson, and I'm from the Los Altos Affordable Housing Alliance. I'm very glad to hear that the town of Los Altos Hills is so concerned about affordable housing. And I'd like to suggest that, in fact, if you are concerned about that, and if you want people building houses to provide affordable units, then it would be a great idea to impose a fee on every single family house that's built, say a $50,000 or $100,000 fee, which would enable you to actually build some affordable housing. Thank you.
Thank you, Anne. Anand?
Hi, Steve Padovan said the quiet part out loud when he said that this is to discourage SB-9 actions. Seems to me that's what's happening here. Councilmember Tyson mentioned that, we want to get ahead of things that might happen because we're not sure how things will go. I would suggest we wait and see how things go before jumping the gun here. We all moved to Silicon Valley. We've all been very lucky. Most of us who live here have been very lucky. Right now, this place is choking without housing. Let's not try to kill the goose that's laid the golden egg for all of us. Let's not be the people who climb to the top and pull the ladder away from believers. Earlier today, we had a wonderful Youth Commission report. In their interest, in the interest of all our children, our grandchildren, let's not try to find ways to discourage the effects of SB-9. Let it run its course. Let's see what happens. We don't know how it will affect our town, if it will at all. Take it slow. If we should go ahead with this plan, we will be ridiculed around the world as being elitist, out of touch. And you know what? We'll deserve all of that ridicule.
Thank you, Anand. All right, any other public comments? Seeing none, I will bring this back to council. Linda?
As far as the low income requirement, I think avoiding lot splits is important. So therefore, I would say the way they have it now, not doing the affordability on a lot that's not split is important, because I would rather not see 8 units put on rather than just the 4 that a single lot would have. So to avoid 8 times as many units in town, I would say just leave it like it is now. And the person who said that if we had allowed lot splits decades ago, that we would have affordable houses. Say you have an acre, which is about 44,000 square feet. If you subdivided that into 8,000 square foot lots, say 5 lots for each lot, now, then it would be very similar to Los Altos. And you would have a median price of maybe 3.3 million. So that still would not be affordable. We would be like a continuation of Los Altos, which is certainly not affordable. So I don't see how he could say that if we had allowed unlimited lot splits decades ago, that we would now be an affordable housing community. And so I don't think that's the way we want to go. So that's just my 2 cents worth.
Thank you, Linda. Any other comments, questions? Stan?
So if I was in San Francisco, a good sized lot would be 3,000 square feet. So let's take a look at a good sized lot and what you could put on it. The houses that are in San Francisco have a median price of approximately $1.6 million. In no way does that make it affordable. So the idea of having affordable housing in Los Altos Hills is very difficult. I don't know what we can do to help people who are in that position. So it might be the government lands that are surrounding us that could have affordable housing because they can afford to do so. But I don't think it's incumbent upon us as homeowners to say that our lots are going to be in that position where they should be made affordable, telling me what to do, how to do it, when to do it. I don't want that. I didn't come to Los Altos Hills for that. And this is not a point of being elitist. It has nothing to do with this. I came here for privacy. I came here for the open space. I think that most of everybody that has come to Los Altos Hills has come here for the same reason. And because of circumstances, we are no longer affordable. So I don't know how to make us affordable, period. So I don't know that the laws that are the ordinance that we're about to pass today, if it passes, I don't know that that's going to help us going forward down the road. I really don't. I do think that it will give us time to think about it a little bit more and come up with just solutions for everybody in some fashion. So if we don't do anything today, then that basically means that SB-9 is going to come full force to us, and we just have a line of contractors lining up to ministerially divide the lots that we have. So I think that before that happens, we have to do something.
Thank you, Stan. George?
Madam Mayor, I do believe that Mr. Sonnenfeld from the YIMBY group sent us a letter and sent another one a little after 7 o'clock. And I do believe Steve Mattas said he would not comment on that until after we'd had public comment. So I don't know if this would be a good time for me to ask if he had a response.
Yeah, I do, Vice Mayor. I would request, though, that the council entertain a 5-minute break, as I would like to just inquire with Steve Padovan about one issue before I respond. So.
All right. Should we just take the rest of the comments the council may have before doing that?
Pardon me, I'm sorry.
Any other comments from anybody, from any council member? Linda?
One last comment. I agree with Stan. We need to do something, and just waiting to see what happens is probably not the best solution, because then you can't go back.
All right, Lisa?
We might have additional comments after we hear what Steve says.
Right.
I think it's possible.
Right.
Sure.
I'm just asking the council to take a recess for 5 minutes or whatever period of time, Mayor, you desire.
Sure, I do have a comment. I do think all of us are all too aware of the need to create more affordable housing in this area. We are aware of it, which is why we have actually encouraged ADUs. The only reason we are enacting this emergency ordinance is because towns are allowed to make certain rules that will eventually impact us for things like zoning. For example, we're saying, yes, you can do an SB-9 subdivision, but there's certain circumstances you can do it. If it's in a forest area, if it's in a flood zone area, if it's in a fault area, and if we were not to do all of these things, then in the end, we would have development where it would be risky and hazardous. So in the interest of looking after the life and safety of our residents, we need to make common sense restrictions on where any SB-9 subdivisions can happen. So that's the intent behind having this ordinance. And yes, this is a preliminary ordinance. And as time goes on, we will be able to put this through a thorough, open public process and come out and have a more regulated ordinance that is more thought out. And I think that's the reason we're enacting this ordinance. To me, it's about making sure that any development that happens starting January 1st is not at risk. It's not in areas which could pose a threat to life and safety, whether it's in a fault zone, whether it's a high fire risk zone, flood zone. So that's the intent as far as I'm concerned. Anyway, with that, we can go ahead and take a 5-minute break and come back.
Steve, do you want to just talk over Zoom or you want to call me?
I'm going to call you, and if you and Peter are both are you both at town hall? If you could just go, Peter, Steve, come to your office, and then if you guys call myself.
I'll go to Peter's office. All right.
Madam Mayor, I think they just need a few more minutes.
Sure, Deborah.
They're just about to come back.
Thanks.
So Madam Mayor, whenever it looks like we're all back.
Mhm.
And so whenever you're ready, Madam Mayor, I'm happy to address the letter.
Sure. Steve?
Yeah, okay. So all council members, thank you. So we did receive a letter this evening, as the council's aware. It was sent in by YIMBY Law, YIMBY Law. There were two versions of the letter. We understand from the author that the second version was simply correcting typographical errors in the first version. There are a series of arguments made in the letter, and I will address them by the topic issue and advise the council what we would recommend to do in response to the letter. The first issue that is raised is with regards to the lots that are exempt from SB-9. And as the council may recall, one of the categories are lots that are subject to earthquake faults. And SB-9 has specific language about the qualifications for lots to be exempted that have earthquake faults. And so SB-9 itself does exempt from SB-9's ability to subdivide or add additional units. Lots that the state geologist identifies as having certain earthquake faults. The ordinance that we put before the council tonight mirrors a lot of that language, but did also specifically refer to any parcel located within Zone F or Zone L hazard zone, which is a town of Los Altos Hills standard. That is, and the council should be aware that even if a lot is within an earthquake zone, but the units are built with the appropriate seismic standards under the building code, you can still proceed under SB-9. And so what we would recommend to the council is that we remove the exemption that is in 10-1.1503, and I'll read that into the record if the council decides to want to consider a motion this evening. And we would instead simply rely on the state law requirement. SB-9 does have language about earthquake faults. It could be argued that our language is potentially more restrictive and not completely consistent with the state law requirements. And so as staff and our office would recommend, we would just remove that definition and instead rely on state law. That's the first change. That's the change that is on page 1 and carries over to the beginning of page 2 of the letter from YIMBY. The next two issues, which are challenges that they have to section 10-1.1505 and 10-1.1506, both relate to the requirement to have one parking space per each SB-9 unit. I will start with the conclusion, and then I'll explain to the council why we are making the recommendation we're doing. We do not believe that the language as proposed by staff right now in the ordinance needs to be changed. And the analysis behind this is that SB-9 specifically defines a housing development as one that contains 2 residential units if the development proposes no more than 2 units, or if it proposes to add 1 new unit to 1 existing unit. So a housing development as defined under SB-9 is either 2 new units or the addition of 1 unit to an existing unit. The language that is cited in the 2 sections that YIMBY identifies, that language imposes the 1 parking space per new SB-9 unit when you only have 1 unit added to an existing unit. So it doesn't assume a lot split, but it assumes you're having 1 unit added to an existing unit. That, we believe, meets the definition that is in SB-9, because SB-9 again specifically says that a housing development contains 2 residential unit if the development proposes no more than 2 new units, or if it proposes to add 1 unit to an existing unit. So we think it falls squarely within the definition of what 2 residential units is under SB-9. The council should be aware that under both the language of SB-9 and in the ordinance before you, and in the letter from YIMBY Law this evening, there is a recognition that the 1 parking space per unit requirement is nullified, if you will, or there's an exemption if the residential parcel on which the SB-9 units are built are within a certain distance of a high quality transit stop or an available car share vehicle. And so the city's ordinance that is before the council tonight does not in any way modify those exemptions. Those exceptions apply. And to that end, if the council were to want to introduce the ordinance tonight, we have a minor wording change that we would recommend to 2 of the definitions that relate to this requirement for 1 uncovered parking space, just to make sure that our language is very consistent with state law in the definition of what a transit stop is. In reality, state law as it's worded is more narrowly defined than even what the town requires right now for the same kind of requirement for ADUs. And so we would just match our language up to state law in that instance, and I can provide language to the council to do that if you wish to proceed. The third portion of the letter from YIMBY is an analysis related to SB-8 and Government Code Section 65858, what they characterize as violations. And so SB-8 is a new law that is going to take effect on January 1st. SB-330 is an existing law. And they both place certain restrictions on a town's ability to adopt regulations that result in a less intensive use or reducing the intensity of land use within existing general plan zoning designations, specific plans, and zoning itself. And to that, I want to just advise the council that what the council is considering this evening is not reducing the development potential on the land. SB-9 allows for the additional units. The ordinance that's before you does not say, whereas SB-9 would allow 2 units, you're only going to get 1. The ordinance that's before the council tonight does allow for the full complement of units that SB-9 requires cities to allow. Los Altos Hills is unique in a number of ways. One, it has much larger lots, and SB-9 only requires that the units be a minimum of 800 square feet. Towns and cities are free to impose other regulations for above 800 square feet. And so the ordinance that's before you will in all instances allow, if the lot is not split, the addition of 1 a minimum 800 square foot unit. If the lot is not split, and if the lot is split on the newly created lot, you would have to allow a minimum of 2 800 square foot units. That's what the law requires. And so there isn't anything in the ordinances before the council tonight that actually limits the development potential of the units. And to take it a step further, to the extent that, for instance, the ordinance before you tonight has some incentives regarding trying to satisfy setback requirements that are larger than SB-9 calls for, the 4 foot that's called for in SB-9. But to the extent that the town has any regulations that would prevent the construction of an 800 square foot unit, the town has to waive those requirements, including setbacks, allowing a potential unit to be built on the property line. And so the regulations or the ordinance that's being proposed to you tonight does not in any way reduce the number of units. And in fact, because it is SB-9, it is implementing SB-9, it's actually increasing the number of units that are allowed to be built on lots within Los Altos Hills. The last issue that's raised is the appropriateness of using Government Code Section 65858. And that we do believe, and we believe the findings in the ordinance support the use of 65858 in this instance. State law specifically allows the adoption of these objective design standards, SB-9 does. It also recognizes that there are certain properties that have inherent hazards, and Los Altos Hills is an area where there's a lot of properties that have inherent hazards because of the high fire hazard dangers. And so what Los Altos Hills is doing tonight in part is addressing those hazard issues that you have within the lot, while not in any way actually limiting what SB-9 otherwise requires the town to allow in terms of additional residential units. All of the restrictions that are being proposed tonight do in fact meet the minimum requirements of SB-9. So you've got 800 square foot units, you've got 4-foot setbacks where that's necessary, and practically you can go to 0 side yard, rear yard setbacks where that's necessary. And you have to keep in mind that Los Altos Hills, as a community that has most of its lots at 1 acre or more, or frankly, almost all of the lots at greater than 1/3 of an acre. There are just different development parameters in Los Altos Hills than you see in other areas where most of the lots are 5,000 square feet, or as one of the council members indicated, like in San Francisco, maybe 3,000 to 4,000 square foot lots and whatnot. And so Los Altos Hills is complying with the requirements. It is not reducing in any way the intensity that the development can happen in terms of the number of units, and it is not preventing the construction of the lots in a manner consistent with SB-9 if the council were to adopt the urgency ordinance this evening. And the basis for it taking the action tonight that it is as indicated in the staff report. You have legitimate concerns about privacy, you have legitimate concerns about noise, you have legitimate concerns about open space and conservation easements, and the impingement into that, and you have legitimate concerns about issues such as earthquake faults and fire safety. And Los Altos Hills, has a history of, because it's so rurally, it exists in such a rural context and rural nature that, power outage and whatnot and fire danger issues are significantly higher in Los Altos Hills than other areas in parts of California. And these provisions are intended to address things. With that, I'm happy to answer any questions.
Any questions for Steve? All right.
And Mayor, if I may, when it's appropriate, I think what we'd want to do is make sure that we capture the motion properly.
Absolutely.
So we may want to share screen and make sure that the council sees the motion before then.
Absolutely.
If possible.
All right, so we heard our town attorney address the issues that were raised by the YIMBY letter. And I too express the same opinion. I do believe that we have legitimate concerns as it pertains to protecting the things that we value in this town, whether it's objective design standards, about our privacy, about our open spaces, about our extremely high fire risk, and about really, we all recognize that there are inherent fire hazards in our town, and what we're doing tonight is just protecting this for the health and safety of our residents. So at this point, I think it's a good time to have a conversation. The other thing we had brought up was about having a conversation about affordability. I could go either way on it, but I'd like to hear the council's about which way the council is leaning in terms of affordability. Steve Mattas did say that if there are more than 2 ADU sized properties, you could maybe say that one of them needs to be affordable when these are developed without subdivision. So I just want to have a discussion about what the council feels on this. And just to respond to the comment that, we are being elitist by imposing affordability restrictions. In fact, that's to the contrary. We're saying that we want to make it affordable by having these restrictions. So you can't cherry pick your arguments by saying that that we're imposing affordability restrictions just because we want to protect ourselves. No, we want to follow the spirit of what this law was intended to be. In fact, we have a hard time as a town meeting our ADU requirements. So we struggle with that, and this would in some way help us. But anyway, going back to what's before us tonight, would somebody like to take the lead on this and start the opening discussion about how you'd like to proceed and whether you wish to have any changes in terms of affordability? Lisa?
I suggest that we take the suggested ordinance the way Steve and staff have put it together and the Planning Commission has vetted it. I think they've thought about it carefully. I suspect over the next several months, we'll add additional things or make minor changes, and then also incorporate what Steve has suggested as more closely adhering to the law. I think at this point, I feel very uncomfortable tweaking the edges of this because this other group of people have put a great deal of thought and time into it, and I'm going to trust their judgment. I think the affordability question you raise is a long and difficult discussion. I don't think we would solve it well here tonight. And I think we would have a chance to address that a little later on. So I'm happy to go with what we have with Steve's suggested changes.
All right, thanks, Lisa. Stan?
Yes, I was the councilman that suggested that the 3,000 square foot lots housed $1.6 million homes. And the entire point of that comment was that it's nearly impossible for Los Altos Hills to have affordability in our town. It really is. The lots are just way too expensive. What I would entertain for affordability and below market rate housing is that we have a time that we set in a separate meeting to talk about this, but this is not the time. The issue is quite intense. And I just wanted to ask Steve a question, Steve Mattas. And that question is, given this letter that I've just seen coming in at the last minute, not knowing how to prepare for this myself, after reading this, what do you suspect would be our liability for a lawsuit if we do enact an ordinance today? And if there is a lawsuit that's initiated by YIMBY, what type of costs are we looking at?
So,
I mean, I'm not talking about buying baby shoes now. So
right.
it's
No,
like
no, I understand.
we're just.
I understand that. If a lawsuit were to be filed, the council could, another organization might request a stay on the effectiveness of the ordinance. The council could agree to stay the effectiveness of the ordinance. And then if it was simply a matter of having a judge decide whether or not the interim ordinance should go into effect, then it is, the exposure to the town would be for its own attorney's fees, and to the extent that the town lost, there's a potential exposure to the attorney's fees for the YIMBY group, assuming they're entitled to them. I don't recommend to the council that I render final opinions on any of that in open session here. I can advise the council of that confidentially if you'd like, but it is, there is potential exposure anytime someone files a lawsuit, and the exposure is at minimum potentially attorney's fees if there's, for instance, a declaratory relief action or something that is filed and a judge were to find that the town's ordinance wasn't consistent with SB-9 or SB-330.
Put you on the spot, Steve, but can you list or can you name a probability of this happening? Is it like 100%? Is it 50%, 75%? Should in fact be passed?
So I don't recommend to the council that we get into that. I will just say to the council, Towards the end of the letter from YIMBY, they do say that they may consider a lawsuit if the town identifies it. If the council really wants to discuss this, there is a threat of litigation that's before you. We could consider adding an item to the agenda and go into closed session to talk about it if the council wishes to do that. I did through my comments when we first came back into session, I did try to address all of the substantive issues in the YIMBY letter. And we did, we are recommending to the council that we make one change that they've requested. We are happy to continue to meet with the YIMBY organization and to share their thoughts with the council. And the council will be considering permanent regulations at some point in the very near future. And so there's an opportunity for further changes if that's the case. At the moment, from a substantive standpoint, the only dispute between us and YIMBY, based on what they have identified in their letter, is this issue of whether or not the town can impose a 1 parking space requirement when there's an existing residential unit and you only add 1 more, or if you subdivide but you only put 1 unit, not 2 units on the property. And obviously it is fair to say that the town will always endeavor to comply with state law requirements under SB-9. We're not trying to avoid them in any way. We may have a respectful disagreement with them about the interpretation, but we are clearly not trying to avoid the requirements.
Okay, Steve.
George?
Well, first off, I just want to say that I again applaud what the staff work has been and also the response to this letter. But I'm feeling a sense of urgency. I feel like we need to make a stand, make a move forward. Granted, we're at the leading edge of this. We're exposing ourselves to some risk from that. But on the other hand, that's what we're here to do. We're here to make judgments best as we can. What I've heard here is that we're making a reasonable accommodation for something that is clear in terms of the language. And so I, in short, agree with everything Councilmember Schmidt said before, and that is, let's move now, let's not wait, and let's set the affordability thing as something that we can decide with a little more time.
All right, with that, would somebody like to make a motion?
Well, then I will. I don't exactly know how to make the motion, but I would say my motion is to adopt the resolution, an urgency ordinance as noted in 9B, subject to the suggested changes made by Steve Mattas.
Madam Mayor, if I may, because we are introducing an ordinance tonight and adopting it, we do have to have the exact wording in the record. And so we can, between Mr. Padovan and I, we can read the final changes into the record, and then the Vice Mayor's motion would be appropriate, incorporating both the changes I would read and the ones Mr. Padovan would make. But there is, I'm hearing something that I think that the council maybe needs to provide a little bit more direction on. The ordinance that's before you does impose affordability restrictions on SB-9 units that are the result of a lot split, not that just when you add the second unit to an existing one. And I'm not sure that the council is completely supportive of that right now. And so we would need some direction from the council as to whether, and I'll be very clear about it, 4 of you would support the imposition of affordability restrictions right now. Because if the answer to that is no at the moment, then we need to further modify the ordinance, because the ordinance before you does impose affordability restrictions on lot splits.
I think, Steve, I think they are supporting the affordability requirement on lots that are split, but they do not want to impose affordability requirements on lots where development has happened without a split. That's my understanding. Is that correct? Yes. Yes. Lisa, did you want to say something?
No, I agree with what you said.
No, I to be completely clear, I wanted to support the ordinance as it is written with Steve's amendments. So
Okay.
I think that was why it was a little.
Okay.
That's been clarified. So as written, it imposes affordability requirements on the lot that has been split as a result of SB-9.
Yeah, and only on the SB-9 units that are constructed on the lot that is split. So if there's a existing house right now that's out there, that there's no affordability requirement associated with that.
Right.
So Steve Padovan, do you want to start by reading your two changes into the record? And we should follow a format of being very specific about what exactly is being changed.
Certainly. So I have, I actually have three, because the third one was one that Brigida, I showed it on my screen, but I'll start with the first two. So there's a code section 10-1, the addition of this code section 10-1.15050. And it states, notwithstanding the foregoing, no housing development project shall be permitted on a site pursuant to this article if the underlying parcel falls within any provision under 10-1.1503 C through M. The second one I have is the addition of 10-1.1506 P. This states, notwithstanding the foregoing, no housing development project shall be permitted on a site pursuant to this article if the underlying parcel falls within any provision under 10-1.1503 parentheses C through M. And then the final one I was going to suggest is, it's a minor one. It's section 10-1.1505A. So it's an addition to that existing article, adding a sentence that says no more than 3 detached dwelling units are permitted per parcel. Those are my three.
Steve, I do have
So
them captured
Steve-
in a motion. If you want me to throw my screen up, we can go through the rest if you'd like.
Not yet. I need to read mine into the record first too. So Steve, that is saying no more than 3 detached units can be constructed on any parcel that utilizes the SB-9 process, right? I just want to.
Yes, and that's just that section regarding not splitting lots. So it's a parcel that is not being split. The commission wanted to add that one sentence just to be clear that it allows maximum 3 detached dwelling units, which is what it's permitted. Just re-clarifying.
On the lots that have SB development without splitting it, without a subdivision.
Exactly.
Pertains to those.
On the lots that are not subdivided.
Exactly.
Okay, all right, okay. So, and when you have detached, you have one SB-9, one ADU, and the primary.
Right.
Exactly.
And the JDU, it has to be joined together, so.
So the changes that I would recommend to the council are, the first one is in the definitions. And this is in section 10-1.1503 sub E as in Edward, which currently reads, any parcel located with a zone F or zone L hazard zone as designated on the geotechnical and seismic hazard zone maps for the town of Los Altos Hills, unless the development complies with applicable seismic protection building code standards adopted by the California Building Standards Commission under the California Building Standards Law. And then it cites the various sections of Division 13 of the Health and Safety Code and by the town's building department pursuant to Government Code Section 8875 et sec. The recommendation is that definition and that exemption be deleted from the ordinance that is before you. And again, we're making that deletion because there is a more specifically worded provision under state law that would still apply. And then the next change is to section 10-1 point. Hold on, I'll make sure it's right here. It's 10-1.1505 sub F as in Frank. And in the third line after at the end of the sentence where it says of the LHMC, then the following would be added to it. it would say, or Government Code Section 65852.21, lowercase c as in Charlie, 1, uppercase A and B, uppercase. And what that is doing is, as the council recall when I discussed earlier, that is making the exception for the requirement for 1 parking space include the exact language under state law that relates to being within a certain distance of a high quality transit stop. So we're incorporating in the very specific state law requirement. That same wording would be added to section 10-1.1506, sub F is in Frank, again after the initials LAHMC in the 3rd line. So it'd be the exact same addition. And so with that, those are the changes that we would propose. Madam Mayor, if I may just address one other issue. Councilmember Mock and I had a telephone call earlier today about another change that I believe he was presenting for consideration, and that I believe Stan originated with a resident. We have looked at that. I don't believe that change needs to be made right now. I think it doesn't impact the ordinance, but if we did make that change, and that change would be to add the words non-primary in one of the definitions, we would have to add another definition to the ordinance of what a non-primary dwelling unit is. But I don't believe that change has to be made because the section itself is very specific about the kinds of units that are allowed under SB-9. So my recommendation to Councilmember Mock, which he's hearing for the first time right now, along with the rest of the council, is that we not make that change. We could look at that further when we either extend the interim ordinance or come back with the permanent regulations, and we're happy to do that. But I don't recommend the change at this time.
All right, so we have a motion. Do we have a second?
Second.
All right, we have a motion and a second. Deborah, would you like to take a roll call, please?
Councilmember Mock,
Yes.
Councilmember Schmidt,
Yes.
Councilmember Swan,
Yes.
Vice Mayor Tyson,
Yes.
Mayor Tonka.
Yes, and the motion passes. Moving on to the next item on the agenda tonight, which is 11 reports from committees, subcommittees, and council members on outside agencies. Item 11A, Vice Mayor Tyson, report by the Undergrounding Committee.